Morning, folks. Good afternoon, rather. It is verdict watch in the Karen Reed trial. Hey, guess what? Laura Owens wrote another article on Medium, and guess who doesn't care? This effing guy. We're going to talk about what may be very well the trial of the century, certainly the 21st century, in terms of the importance of this trial involving the Commonwealth over there down in Massachusetts. This trial has implicated law enforcement like no other. It has completely obliterated confidence in law enforcement's ability to collect and marshal evidence and to extend some measure of confidence amongst the general public in terms of their safety, in terms of people maybe not getting framed for crimes. Look, I don't know if the defense has done enough to prove that Karen Reed was set up in this case. I just know that the prosecution has certainly not proven first degree murder. So, day and a half of full on jury deliberation so far. What do we have? At this point, I feel for the attorneys in this case because, hey, Dominic's in the house. What's up, Dominic? If I add you to the thing, I'll let Dominic figure that part of it out. But if maybe lose my train of thought, I want to make sure that I don't know how to stop this little pinging thing. I'm just going to close it. All right. So day and a half. I feel like after you try a jury trial, it is one of the most painfully insecure moments for an attorney, because on the one hand, you're so utterly exhausted. 31 days of trial. I mean, you're talking about 2 months constantly in trial. And you're worried about whether or not you did enough, whether or not you presented enough, whether or not you made the right arguments, whether or not you may have dropped the ball. What if we introduced this other thing? What if we let Karen Reed testify? What if we did a lot of things? You start second guessing yourself, and your clients almost without fail will always ask you, hey, so is it a good thing that the jury is still deliberating, or what do you know, or what do you think? And truthfully, there's not really a good way to answer that, because sometimes, I mean, I've seen juries come back in 15 minutes and deliver guilty verdicts. I've seen them come back in under an hour and deliver not guilty verdicts. I've seen them deliberate for 3, 4, 8 days in the most extreme case and come back as a hung jury. And I've seen them deliberate for similar amounts of times and come back with a verdict of guilty. It's just, there's no predicting. What I can say pretty confidently, like 98% positive, that there is not a chance right now that the jury is considering first degree murder as an actual verdict. And the way that the juror forms were laid out, somebody had sent me a copy of the forms that they're actually using. The way that they're laid out, it presents basically 4 options. Either she's guilty of first degree murder, second degree murder, involuntary manslaughter, or some lesser thing, lesser included. There was some objection by the defense attorneys as to the way that the verdicts read, because it's like, how are they supposed to check or let you know that they're not guilty? There should be a box that says not guilty. And then the judge is like, yeah, we've been doing it like this for a really long time. All they got to do is not check the box that says guilty, and then I will know that it's not guilty, which I guess fair. I mean, the jury is not idiots. And I'd imagine if they wanted to vote not guilty, they'd just ask the judge that question and they would be instructed properly. But I thought it was just interesting. There are some people that think there's shenanigans going on with the juror forms. I don't think so. I think that's probably just the way that they do it. It's really not that complicated. If the jury wants to acquit, they're going to do so regardless of how complicated the forms are, whether or not there's a little box that says check this here. So here's my thoughts of the case. So I just sprayed myself in the face with whiskey. Ooh. That was one for the Patreon backstage bloopers. Look, there's multiple different plausible ways that this Karen Reed situation went down. None of them involve Mr. O'Keefe being ran over by Karen Reed's car. That did not happen. I know that a lot of you have a lot of opinions about this case. And when I did my introductory leading up to the trial video podcast, maybe about a couple months ago, about this, long before the Lower Owens thing ever grabbed hold of this channel for a brief spell of time. I wanted to know a few things. Number one, is there any evidence whatsoever that Karen Reed, on the way to go and discover John O'Keefe's body, is there any video evidence showing that she damaged it on her way over there? Turns out there is. What was the medical evidence going to be with respect to their opinions on how Mr. O'Keefe passed away? The doctors that came on and the accident reconstruction people that came on and presented evidence and testimony, none of them said that his injuries were consistent with being hit by a vehicle traveling 25 miles per hour in reverse. One of the medical experts who used to work over here in the county that I practice, in San Bernardino County, straight up said that, look, the guy had a laceration in the back of his head, the right back side of his head. There was multiple fractures that was consistent with him having blunt force trauma to the rear of his head, consistent with a fall, maybe perhaps against asphalt, maybe against some kind of hard object, maybe against some other thing. I don't know. But, you know, significant was the fact that there was snow on the ground, that there was grass. That kind of injury would not have been sustained falling on the soft ground. Could it have been sustained by a vehicle? No, it could not have. I would have expected to see significant bruising in the area, and there simply wasn't any. There was minor scratches here. There was superficial lacerations on the front of his face, namely his eyelid. I thought it was notable and extremely confusing that there was the injuries to his arms were consistent with animal marks, dog marks, but they didn't find any canine DNA. I think I want to say that somebody found pig DNA. It's like, well, how does that even make sense? I've heard a theory that maybe it was some transfer from some dog treat or something, which still begs the question: if you got a dog chewing on somebody's arm, how does that leaving pig DNA as opposed to dog DNA, even if it's secondary transfer from the treats? I don't know. That part kind of threw me for a loop. Another part that was introduced for the Commonwealth's case was the fact that one that I can't really wrap my head around is that, okay, so if she did not run him over with her vehicle, how was it that there's like microscopic remnants of the taillight embedded in his clothing? And then, of course, the obvious is, well, obviously, because the cops planted it there. Look, there's any kind of theory like that you would normally dismiss outright. But the way that this case was investigated, literally collecting evidence in a Safeway paper bag, using these plastic cups that were purchased in a paper bag. I got to do something about that beep. Hey, Dominic, you hear that beep?
Yeah, so go to your webpage that has a Discord open,
Yeah.
and then if you go to the left, if you're using Google, it should be like where the search engine's at. Go to the left of it, and then click on site settings. Do you see site settings?
No. Server
Uh,
settings, server insights.
no, so at the top where your Discord is at, the like search engine, it
Yeah.
should have like three little lines next to discord.com. Do you see that?
Oh, I see something that says notification settings, nothing. How about that?
Yeah. Yeah, you gotta turn the notifications off, or just completely close out Discord and it should stop.
I already did all of that. And my boomer self, my Gen X self didn't do it right. So there's that.
Okay.
Hey, if y'all are in the Discord, what are you doing? We're live right now. We're live right now. Y'all gotta hear about this Karen Reed stuff. And man, I literally almost sent you a gym selfie today. It's like, juicy arms, huh? Well, check this out. I was like, what am I doing, man?
I'm rubbing off on you, man.
What have I been reduced to? I'm not a gym bro. All right. Hey, Grandpa Mustard brings up she says, okay, I'm out of here. I started listening, thought you sounded like an intelligent guy. That quickly changed when you said there's no evidence that she ran him over. You're clueless. Well, thank you for that. But there's literally doctors that said that, yeah, his injuries are not consistent with being ran over by a car. None. there was an accident reconstruction person that came in with their expert witness and said exactly the same thing. So if you think that I am clueless, I guess they're clueless too. And well, luckily for Karen Reed, I guess you're not on the jury to do anything about it. So take a hike if you need to. I ain't gonna miss you, not at all. Yeah. So look, there's 4 different scenarios that I can gather. One of them is rather incredible that okay, so Mr. O'Keefe goes there the night he goes there, he has his cocktail glass, he's walking inside the house, and there's some kind of a beef because one of the people involved in the house are romantically involved with his girlfriend at the time. And as a result of that, there was violence that ensued. Maybe there was like a pushing or a shoving match, and he falls and cracks his head on the end of a table, and then everybody freaks out because he's, and like this whole thing. Maybe the dog, the German Shepherd, jumped on him and created those injuries, and everybody freaked out, and then there's this big cover up. That is a plausible scenario, maybe. I don't know. It's not one that was proven, but it's something that you could reasonably consider as maybe that was a thing because the prosecution, you hear that beep again? Whatever you told me to do, it didn't work, Dominic. The prosecution didn't do anything to come off of their one theory that, okay, he was definitely ran over by a car. But look, one of the biggest questions that I had in terms of the medicals, okay, so if he was hit by a car at 25 miles an hour, as was presented in the prosecution's case, how is it like, what would those injuries look like? Are they consistent with what he was found with? And then this one doctor who was the most convincing to me comes on and says that no, if he was hit by a car at 25 miles per hour, and I've been doing this since 1991, he would have significant bruising. He would have injuries on his legs. He would have injuries all these other places, not just this singular blow to the back of his head. What is the injuries that I saw? And then on cross-examination, they asked him, well, what if all of these things and this and this and that? And the doctor was like, well, if all of those things happen, then yeah, sure. But I just don't think that's what happened based on what I saw. All right, I got to
Do you
stop.
do you wanna pause the live, and then I think you could share the screen with me while the live is paused, that way I can see where you need
Yes,
to go to mute it?
let us do that. All right,
Okay.
I'm going to mute myself. Hey, Dominic,
Yeah.
whatever I
Let me
do.
I'm calling you right now, hold on.
Okay.
Just mute your mic.
All right. All right, let's come back. All right, we're back. Sorry about that, folks. Normally one of the things that would happen or not happen if Dominic was here, but what are you going to do? All right. So Amy Bonner says, didn't they ever swab his arms? I thought I heard they only heard pig DNA and no dog DNA. Yeah, that's what I thought I heard too. And look, I have not watched every single minute of the trial. I watched pretty much the highlights. I had 3 questions. What evidence did they have of the taillight being broken at the place? And was it really true that they had a video of Karen Reed breaking her taillight on the way over there to discover O'Keefe's body? And they did. That came out. And then the doctors that testified basically said that, look, his injuries, if he was really struck by a car, I would expect to see massive bruising and further fractures on other parts of his body. It wouldn't be confined to what we saw. What I saw was consistent with something else, just not a car accident, basically, essentially. I'm not saying they didn't try to present some evidence to suggest, of course they did, because they had their witnesses. I'm just saying I believe the other witnesses when they said that it's not consistent with what we saw. It doesn't make any logical sense or physical sense because of the reconstruction that came in. McCref says, or McCrae, is that McCrae H says they did not swap the wounds in his arms for either plastic or dog DNA testing. Huh. It doesn't make any sense to me that there would not be any dog DNA. I wonder why that was, because I don't remember them making any affirmative statements or anybody stating that they had saw that there was DNA from a dog there. Matter of fact, one of the experts, I think it was like on day 29 or 30 of trial, basically said that on one of the questions on cross was, did you know that there wasn't any DNA from a dog? He's like, oh, well, I didn't know that or whatever he said. But he said, number one, the wounds that he had on his arms are consistent with somebody sustaining those arms while they were alive. In other words, if the theory was, well, maybe he was attacked by a coyote while he was laying there deceased in the snow. And the doctor's like, no, those injuries were sustained during life. And he gave reasons for why that was. But the biggest takeaway for me, if those injuries were all sustained while he was alive, then one of the alternate theories for the prosecution was, look, the bite marks on the arm looks like he got attacked by Wolverine. That had to have happened by some kind of feral animal or something. No, because the defense has been saying all along that he was perhaps attacked by a dog. Maybe there was an altercation inside the house. Maybe the German Shepherd dog that they got rid of attacked him in some kind of lover's quarrel. Maybe he hit his head on the back of something and they dragged him out in the snow, and this was this big cover-up. Look, all I'm saying is, I'm not saying they proved that there was a cover-up. I'm not even sure if I believe that there was a cover-up, because it might very well be the fact that it wasn't a cover-up. It was just really shitty detective work and marshaling the evidence, collecting of evidence, and all of those things. For all of those reasons, you have reasonable doubt. You can't trust the investigation. There's so many things that were done wrong. And in closing arguments, they pointed at a lot of them. And we're going to review the closing arguments in this case. Since we don't have a verdict and we don't have a lot better to do, I think that the defense attorneys did a wonderful job, even on Lally's part. I've heard a lot of complaints about Lally for the Commonwealth. If you believe that jury trials are theater, then you have to have some measure of charisma. And I believe that Lally does have some. I just think that in comparison with Jackson, it was just, it was a mismatch of styles. And Lally's style was one where he was very deliberate and unwilling to bend in his theory of the case. He didn't even in his closing arguments offer for the possibility that, okay, so even if you believe that Karen Reed did not strike him with the vehicle, at the very least, she sideswiped him as he threw a alcohol glass or whatever kind of glass it was, like a capita, some kind of a drinking glass at the tail, like causing it to shatter. And then he fell and hit his head, and then she sped off and took off, offering some kind of viable theory for involuntary manslaughter. He's hell-bent on trying to convince the jury that Karen Reed's vehicle was the main culprit in the death of Mr. O'Keefe. And if I believe the experts in this case, I just believe the doctor that said that had that happened, then we would have seen these other injuries. And even the physics expert came in and said that, look, the problem with this case is I don't know what's going on, but the physics and the science of it all does not support what the prosecution is saying. And that was basically how they closed it. Before I get into that, McCrae, thank you so much. You're so kind. She said they only swapped the clothes months after. Yeah, see, that's the problem with it. They only swabbed the clothes months after and used one swab for all holes they found. If you're of the mindset that they perhaps planted evidence on O'Keefe to make it look like Reed's car was responsible for this, then maybe they planted remnants of the taillight, because there was that. You can't discount that there were remnants of the taillight on O'Keefe's body. How does that get there but for being struck by the taillight in some capacity? That's problematic for the defense's arguments. But it's not, this all-encompassing thing where they're going to win the case off that one little fact, because there's so much other doubt. I don't trust the investigation. I don't trust that there wasn't something done to dispel with possible other DNA, for example, from a dog. Like if the cue to that German Shepherd was, hey, go attack O'Keefe, I got to believe, being experienced police officers, they would have known how to cover that up in some regard. And I don't know. I mean, the evidence never took that direction, but if you're deliberating in this case, you got to imagine that's one of the questions. Have to imagine. I don't know. Here's one theory from Liz Bird. She is our British liaison. I think she volunteered in the Discord. She says, here's her theory. Went down to the basement, starts taking shoes off because that's what he does in any house. Dog lunges at stranger. He loses his balance, hits his head on the stairs. Yeah, that's one viable theory. The guy was drunk off of his ass. Karen Reed was completely toasted, blackout drunk. I forget how many drinks that it was exposed that she had consumed. But for being her size, she was a smallish, petite kind of woman. She had a lot to drink, and they were bar hopping in their 40s, no less. Hey, Dominic, how often do you bar hop at 25 years old?
I want to say I go every weekend, every Friday night or Saturday night, but once a week usually.
How do you even have the energy? Jesus. I don't bar hop ever. I find a place and I stick with the place, and that's it. I don't find the need to go hopping around. They all serve the same alcohol, more or less. I digress. But no, that's a viable theory, Liz. It's there's that, and there's the other theory that, okay, maybe she just got pissed off because she was really mad at him. The phone calls that they played in court where she's screaming at the top of her lungs, I hate you, and all of this stuff. They did bring in a lot of evidence that there was issues in her relationship with O'Keefe. She had complaints about how much time he was spending with the kids, thought it was taking up some of her time that he would be spending with her, which kind of put her in a really negative light. Excuse me. And so one of the theories might be that she was so upset by something that set her off that she did maybe reverse. It was like the one big whatever, doesn't know that she was like coming right at him, and then he's trying to dodge out of the way, sideswipes him, and then he hits his head on some kind of hard object. I don't know, maybe frozen terrain. I remember that on Cross they asked one of the doctors that specific questions, and he's like, yeah, sure, it's possible. Any hard object. It was a hard object. Obviously, the wound in the back of the head, he got hit in the back of the head with something. We just don't know what. We know that there was a laceration. There was multiple skull fractures, probably resulting from that one wound. There was blood swelling. The doctor said that he would have been immediately unconscious and hypothermia and all of that. So you have that theory, but if that's your theory, that's not first degree murder. I'm not even sure that that's second degree murder if you can't prove that O'Keefe was hit by the car. And if I'm on the jury and I'm sitting there and I hear a doctor say that had he been hit by the car the way that the prosecution suggests, I would have expected to see major bruising. I just don't see it. And then the defense is telling me this alternate theory that perhaps there was an attack inside, perhaps there was a boxing match inside, perhaps he was attacked by an animal, perhaps a lot of things, but he wasn't hit by a car. That's reasonable doubt enough to get me to say acquittal. Look, I don't know what happened in there, but I don't have enough to send a woman the guilty verdict on a first-degree murder charge, certainly. Not even a second degree murder charge, because if it's the side swipe theory, you don't even have intent. You need intent for second degree murder. Obviously for first degree, but for second degree is a heat of the moment killing where you form the mens rea to take another person's life in some emotional outburst and cause the death of another individual. But if it's the side swipe theory, that's not what happened. So how do you even prove that intent? All you can prove is she was really mad at him. What you can perhaps find her guilty of is an involuntary manslaughter, but you would have to believe beyond a reasonable doubt that something that Karen did, her driving while under the influence, caused the death of O'Keefe. How do you even get to that part when there's so many different plausible alternate theories on the case? So I don't know what side you're on. And, all the best to that lady that said that, she's dipping out because obviously I don't know what I'm talking about because whatever. Look, lots of luck to you. You hurt my feelings, not really. And you're welcome to show yourself the door. But look, if you're trying to make the argument that there is proof beyond a reasonable doubt of anything on this case, then you have just not been paying attention to the case, or you are rooting really hard for a specific result because of some emotional reason, because of something that you've attached yourself to this case that means far more to you than anybody else, that goes far beyond the facts in this case, and I'm not going to have it. You're welcome to take a hike and join some other channel that will accept that kind of thinking, because we just don't play by those rules over here. Hey, Starchasm tells Dominic to enjoy his 20s. Ain't that the truth? Hey, Dominic, like in 5 years, which is like tomorrow, you're going to wake up and you're going to be like 30. And then you're going to be like, holy shit, I got to get going in all of this. There's the other thing. Yeah, shards were not found till 3 to 5 days later in this case. Who's to believe look, I know what the crime scene looked like, but I also know from the officers that were on the stand watching their testimony, the way that they were so brazenly being condescending to Jackson on the stand and trying to talk to the public is what it felt like, as if we were stupid. I just don't believe anything that came out of that criminal investigation for the first couple of days. You had inverted videos, you had manipulated evidence, you had evidence that wasn't passed to the defense team for years later, literally over a year later. What is really going on over there in the Commonwealth? I want to take a listen to the defense's argument and score it. So if I'm scoring closing arguments, if I'm scoring the closing arguments in this case, Jackson did a masterful job in the time allotted. I thought that Lally did an acceptable job. The problem is he was going up against this masterclass in defense team closing statements, and he doesn't have a lot to fall back on in terms of what was presented in the case that he could focus on. To him, the most relevant part of evidence that he was hanging his hat on was the statement that she made, the partial admission to in his mind, I hit him. He kept on saying that over and over and over again. Not only was he saying that on his closing arguments, he said that he was repeating that in his opening statements, and he was repeating it to doctors in this case, the expert witnesses in this case. Did you know that she was saying, I hit him, as if it's like the big point? It's like, okay, we get it. We know she said that. She was also blackout drunk. I don't think she even knows what happened. If she did hit him, maybe she thought she did. She's trying to connect the dots of, how is this guy dead? Did I run him over in my car? Is that what happened? And if she has that belief, was that planted by when she gets there, or some other person that she's spoken with, telling her that that's maybe what happened because the guy's just laying there in the snow? I don't know. I don't know what happened. There's just too much doubt for this to turn into a conviction in my eyes. And the fact that we're a day and a half now in a deliberation, if this goes past day 2, it's like 90% this is going to be a mistrial, which maybe it is, maybe it's not. I don't know who's on the jury. I do know that they started with an exorbitant number of jurors and we're down to 14. And so like now is the time. I do know the jury is pretty sick of this case. They have to be. I mean, they've been sequestered now. Well, I don't know. Actually, I don't know if they've been sequestered, but they've been on this case for a couple of months. And gosh, they're having to go through all of this evidence now. The judge is not giving them any additional evidence. He said, look, you got all you're going to get. They asked to go home early today, like at 4:00. Starcasm with the 10. Thank you so much, Star. She says she texted him, she hated him, and then tells Brian Higgins, John's dead. Want to date me? I added the date me part. Oh. Did she really do that? Was that a text message? Look, I haven't been paying attention to all 30 days of trial. Did it come out that there was a text message where she's telling Brian Higgins that, hey, since John is dead, do you want to date me? Was that a thing? Hey, Dominic, do you know if that was a thing? Teresa says that she didn't say it. That's one person saying she did. Did I hit him? Then she changed her story. Nah. Why was the jury excluded from some information? Well, if there was information excluded, it just wasn't relevant to the case or admissible. It had been deemed probably in pretrial motions to be inadmissible, and if there was anything that came out that crossed those lines to prevent a mistrial, it would have been excluded from them, and that would have been issues that the attorneys would have known about it for a long time, probably pretrial. Let's get to some of these closing arguments. I think that it's instructive to watch Jackson and his closing arguments. It's one of probably the top 3 closing arguments I've seen over the last 10 years. Let me get to this.
So because of that, you have to put your notebooks away. All right, so if you just put your notebooks away and just listen. So we've all seen how hard the lawyers have worked for this long period of time. And we've all noticed that you've paid great attention throughout the entire trial. I'd ask that you extend your courtesy to the closing arguments. And in Massachusetts, because the
commonwealth galore, just look the other way. That's what they want. That's what they're counting on. But the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Kieran Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America, lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator.
This part of the closing argument was so powerful. And I'm not a big fan of like the bloviating, Gingras' word, 2-minute warm-up leading up to this, but this part right here was one of the most powerful moments in his closing argument, and really one of those powerful moments in closing arguments that I've seen in recent memory. But this is what he hits the jury with.
Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen.
Now, he says that. Pokey, thank you so much for the 5. By the way, is that you in the picture with the car over there? Is that like a monster truck or whatever that is? Super sticker of well, I don't know what that is, but thank you so much. So he says all of that, and you recall when they had McCabe on the stand, when they had Trooper, what's his name, was on the stand, and they were asking for explanations about the things that Jackson had just outlined, about the butt dials, about, the hiding of evidence, about not doing this or that, about the doctoring of things, about not supplying certain items of evidence until, almost a year and a half later, about the inverted videos, about all of the things that he said. And there was points in the testimony where you could point to every single one of those things. So when they're deliberating on the record and they're going back, it's like, well, son of a bitch, all of those things really did happen. And he came in making promises in his opening statement that, look, it's the wildest thing ever. You wouldn't believe it. You wouldn't think that in 2024, with everything that we know, that this would happen in the trusted Commonwealth over here in Boston, Mass. But son of a bitch, it sure as hell did. And it happened to Karen Reed. And why? And then he goes, and the way that this case played out, they set up all the relationships. They set up this web of law enforcement. They set up a reason why it would happen. They introduced motives as to why it would happen. And there was never, ever, ever a good rebuttal or retorts for the prosecution to fix it. He leads with that. And when you teach trial advocacy, one of the things that you speak to is primacy and recency. And if you're grading this as a closing argument, I would have led enough with the throat clearing stuff for the first 2 minutes. I would have led with this, 3-paragraph diatribe about the unreliability of law enforcement and their investigation into this case, because that needs to be at the forefront of the minds of the jury whenever there's a question about why this evidence, why that evidence. Well, how could we rely on it anyway? Because of all the things that we know that they're willing to do to manipulate and hide the evidence because of a cover-up. It was brilliant theater, and he executed it brilliantly. I'm not normally a big fan of people reading their closing arguments, but this guy does it really well and effectively. Let's continue.
Right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Read and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Read dropped him off and he walked into 34th Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house, and when he was caught and asked to describe that man, he had to. It was a little bit vague, but you remember what he said. He was tall, with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family?
I wanted to respond to some of your questions. Where is the blood pool from this head? That's a really good question. That's probably going to be asked or has been asked in jury deliberations already. Exactly. Where is the blood pool? Because if it was outside, then that's not a big deal. They don't have to do anything to plant that, right? But if it happened in the basement and it wasn't ever found and he was planted in the snow, I guess they wouldn't find it, because they were not only controlling the investigation, but they were planting evidence and diverting attention of the evidence where they wanted it to go, which was anywhere but on them. It's more damning to me for law enforcement that there wasn't a pool of blood found, because very clearly dude had lacerations and bleeding in his skull. I don't recall any direct testimony that would have spoke to how much blood would have been found, but I think it's very damning that there wasn't any blood found that would have came from the injuries that he sustained. But let's continue.
How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial. It was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monotonic time, it aligns perfectly.
That's pretty important, because that was the other narrative, wasn't it? That the Apple Health data shows that he was going inside the house. So you can't tell me then that, okay, and then they bring in this other guy to say, but what about Waze and all this other stuff? The defense cleared it up they may not have cleared it up in the minds of everyone definitively 100%, but they offered a theory that makes logical sense based on the expert testimony that was presented. You can't ignore the Apple data that says that he went inside the house and up and down flights of stairs, that he was in there for a spell. The theory of the case going in was he never went inside the house. That was the statements of the people that were inside the house. They were the ones saying that. And so when you have Apple data that is saying to the contrary and you try to do away with it with ways, look, I'm not the best when it comes to technological stuff, but it doesn't make any sense that the prosecution didn't have a good response for that or a good retort. And even if, you could say, okay, the ways, whatever, if you believe the prosecution's theory that somehow it wasn't reliable, it's still reasonable doubt. They still have evidence of him being in the house. Regardless of whether or not you think it's wrong, it's not definitively wrong. And if the standard is reasonable doubt, then you can't rely on the fact that you have to do something about the Apple data, which was not done, in my opinion, in this case.
They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview. 25 meters at 12:32 after she left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie, and Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit.
True.
That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview.
Yeah, before we do that, Scott makes a good point. He doesn't believe in any conspiracy theory. I don't think that you have to believe in the conspiracy theory in this case. My only point in bringing up the conspiracy theory, because I really honestly, it's not plausible to me that he was murdered inside the house and somehow all this evidence was planted. There wasn't enough evidence presented to get me to believe all of that, because it's equally as plausible that they were just incompetent and they were all friends with each other and looking out for each other. They weren't responsible for his death, but they didn't want any of them to get in trouble. And so they behaved stupidly and made it look like and opened the door for people to argue that there was a big conspiracy theory. It's perfectly reasonable to suggest that perhaps the guy was just drunk off of his ass and he fell and tripped and hit his head off of something. Maybe he was attacked by a coyote. I don't know. Maybe he was attacked by some other dog. I don't know. We won't know, because the dog in the house and the DNA, we're not going to have a match. It's just never happening. So are we ever going to know what actually happened? No, we're not, man. But the very fact that we could come up with like a dozen different plausible scenarios of how O'Keefe died without implicating Karen Reed is problematic for the prosecution, which is why I don't think that they're even considering first-degree murder at this point. If they're considering anything at all, it's basically, did her actions, regardless of whether or not she intended it or not, lead to his death? It's that involuntary manslaughter charge that is problematic, that they're trying to figure out whether or not she's going to be guilty of that or not. But I digress, because there's also some really important stuff coming up that Mr. Jackson's going to say, and I think we need to hear it.
Fairview. Brian Higgins show up drunk at the waterfall. They'd been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You can see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together?
Sarcasm, that's crazy. I don't have a Fitbit. I don't have any experience with it. But if you have experience climbing stairs, my Fitbit used to have me climbing stairs when I was getting in and out of my truck. It does provide false info. But is Fitbit the same thing as like the Apple data thing that was like, I understand that it could give false info, but that thing had him going up and down 3 flights of stairs. And my only point in that, and maybe it was false information, maybe it wasn't, but the prosecution didn't do anything to combat it and make it not a ringing gnat inside the jurors' ears is my only point.
Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, you know, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done. What was that? 5 seconds? 10? Doesn't take long at all.
Aggie, I don't know if I buy the vampire theory, but thank you so much for the 5. But maybe that's what happened. They feasted on O'Keefe. That's where the blood went. The McAlberts are vampires, ritualistic sacrifice for birthday boy. Makes more sense. Maybe. That would go along my group of least plausible theories. I haven't heard any evidence of that. But sure, throw that one into the mix. Why not? Why not? Since we're doing it.
And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted, yeah, I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehome, never to be seen again. This was a dog they'd had for 7 years. Yeah. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something
A dog with bite history, a dog that we've had for 7 years. On our Discord, we have like this Tilted Lawyer Pets channel. Every guy, that's like the most popular channel on the Discord. Everybody's posting pictures of their dogs. You have a dog for 7 years. You're not just getting rid of it. It's really suspicious that you got rid of basically a family member, a significant one. I don't know. Let's continue.
Thing about the dog, they did not want law enforcement to find out. Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed. 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, and just in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. By the way, come back over. I need help moving something heavy. How long did that take? 15 seconds, maybe?
McCray with the 5, thank you so much. He says, plus they kept referring to the dog as an it. Offended this dog owner, and I have GSD, a German Shepherd too. I made sure to train him so he does not bite. Yeah, those are big dogs, man. But yeah, I do remember that.
The odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. And that's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would have.
Hey, folks, pause. I have to go attend to the tilted uterus. I'll be right back. Oh. Hey, Dominic, cue a commercial.
Obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34th Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard.
Hey, Don, can you hear me? Hello?
Yeah, you're kind of lagging though. I don't know what's going on. Can you hear me? Omar.
Backyard is serviced by a side fence.
Yeah, the video's lagging too.
Side fence accessible to the front yard, the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was in fact
Each speaker is color-coded in the text.
Thank you so much for the $9.99. Here,
Cursing money.
yeah, I need to have a cursing jar. I really do. That's
I think they were paying you because you're going to get demonetized.
Yeah.
I'm already there. I'm just counting on it. Like ever since I started doing these live streams, like I'm just accepting I'm going to be demonetized. It is what it is. All right. Let me get into what Owens had to say. When judges played doctor, all right, I had to contain my anger when I was reading this, because look, here's a young lady. By the way, I've been thinking she was 29 years old this entire time. She's actually 34 years old.
Yeah.
Like, wow. Oh, I've been very kind in my analysis of Laura, and I was really hoping that she would take this opportunity to reverse course and find some peace. Maybe go up to the mountains for like a month or 2 or 6 and find herself, get onto some peyote, maybe do some mushroom, maybe do some ayahuasca, rediscover herself, realign her thinking. But she's tripling down, which is sad, because it means that she is a prisoner of this narrative and she just can't get over it. And unfortunately for her, she's caged. Hey, are we back? Are we back on? Sir?
Yes, sorry. I was showing them the recent TTL clips while you were gone.
Oh, well, that was very nice of you. Let us resume with the closing argument. I had to go retrieve the tilted uterus, the tilted sandwich maker. And she's here. She's on the couch. She don't want to be on camera, but she's on mic. And she's still being really shy. She ain't saying anything.
I was not prepared. Apologies.
Well, you got to live with your decisions. Just how it is. All right, let me get back into what we were doing. Got to find it again. Oops. Echo. It was this one. All right, let us resume. Okay, so to set the stage again, my apologies, folks. He was talking about all of the grave injustices that the law enforcement had committed in terms of hiding evidence and being disingenuous with their statements and their police reports. Let us continue with this brilliant closing statement by Mr. Jackson.
You got to share your screen.
Cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. And being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John.
So this part of the arguments is critical because he's putting it in the middle of his closing arguments because, like we said, the primacy and recency thing. He put the most damning parts of the middle in the middle, or of their case in the middle, because you're trying to sandwich them in between your best stuff, bookend them between them. But they have to deal with the fact that she sent those messages and that it creates a situation where she was explosively angry and emotional, and perhaps being blackout drunk. Maybe she didn't remember that she ran this guy over with the car, or sideswiped him, or did something that led up to his death, maybe. And so this is really the strongest part of the prosecution's case. The fact that she was really pissed off and really drunk. It's really bad mix. It was inclement weather conditions. There was a blizzard going on. It was like 35 mile per hour winds or something like that. And she was behaving and leaving angry voice messages, and obviously in an emotionally distressed state, reaching a fever pitch. And is it possible that in her haste, she did something to cause the death of Mr. O'Keefe? These, in my opinion, is what the jury is deliberating about right now. Is she somehow responsible for this in any degree? I don't know, man. But this is the strongest part of the prosecution's case to me.
But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, her question was answered, and her worst fears were realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish.
Melissa, it wasn't proven like beyond, like they don't know what her blood alcohol was, but we know that she consumed like over 10 highly alcoholic beverages. With her body weight and her medical condition, she was blackout drunk. It's not been proven to what degree, but there's not really a dispute that she was heavily intoxicated.
Can you remind me, what was her medical condition?
She had like a colonoscopy or something well, I don't know specifically what it was, but she had something wrong with her colon. She had like 10 surgeries within the last 13 months that affected her. And the officers were going back and forth, making fun of her condition, talking about she was dripping poop because of her stuff. These were text messages between law enforcement people that were close to the investigation, just having a good time at her expense. But yeah, they never mentioned, well, at least I don't know or remember them saying that what her specific blood alcohol was, but there's not really much question that she was heavily intoxicated.
You could see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense.
Yeah, that's not really refuted evidence. She did call him 53 times. You don't call somebody 53 times to leave like this false record that, oh, I didn't know he was dead. I was trying to get a hold of him. Not 53 times you don't. And the times that we've seen that, like in the Watts case, he left a message for his wife asking her, hey, we're planning the thing in Colorado or whatever, is just like to cover his tracks. In other cases, we've seen like 1 or 2 text messages, not effing 53. If I didn't come home and it was like 6 a.m. and you were looking for me, you would text me 53 times. You'd be really angry. You'd be cursing up a storm the same way that she was. And you'd probably run me over with your car. I just want it to be known as a record that this is what I think would happen in case I need this as an exhibit anywhere.
That is not true.
Bullshit.
I would not call you 53 times.
You'd call me the once, and it would be like the once. This is your warning, bitch. Get your ass
I
home.
call you a few times, but there's no need to call more than twice.
Well, I would probably call more than twice, but then I would like go on a Rambo search, trying to find where you were. I'd probably call your sister.
What does make sense
That makes
is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. The actual video, you can see that tire move. I'm only going to show you.
Did you hear what he just said? Replay that, because that was one of my critical, in terms of evidence that would be dispositive to the outcome of this case. What would I need to see? Evidence that the taillight was broken in a manner other than running over O'Keefe around the time of the incident. And listen to what he just said.
He hit John's Traverse and murdered this man. And then after that murder, she called him not once, not twice, 53 times.
Oh, I remember.
It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent.
All right. So then my question is to that lady who she said that she thought that we had intelligent information, but obviously we're clueless. And she escorted her way out of the chat. My question is, let's assume she's on the jury. Let's assume anybody's on the jury. How do you look at this evidence that he just brought up and that picture that he just showed on the screen? And you see the evidence of the taillight, not destroyed, cracked, but not destroyed at 5:07 in the morning that day. And the prosecution has done nothing to present an alternate theory of the case other than the taillight was destroyed when O'Keefe was struck by the taillight, and that's how it happened. How do you then conclude beyond a reasonable doubt that the prosecution wins this trial? I'm curious to hear anybody's theory about what is going through their mind if the answer to that is yes. And if the answer is no, and 99% of the time it should be no, then what is she being charged with first-degree murder for?
I have a quick question for
Yeah.
you. So if they're saying that the taillight was cracked before this supposed, hit, how are they saying that they recovered a piece of that, or the supposed cover-up placed that.
So at first it was
At the
like
scene.
there was 5 pieces of the tail light, and then there was 3 pieces of the tail light. They recovered it at the scene. There was shards of the tail light embedded into the clothing of O'Keefe that was found days after the night of the incident, which is why the defense is coming up. Well, obviously that can't be the case because of what we know. And so then they came up with this theory that it was obviously a cover-up because of the good old boy circle over here in law enforcement. They're looking after their own, and they're trying to make sure that the homeowners don't get into trouble. So they're planting evidence. Hey, look, her tail light is already cracked. How hard would it be to just like, I don't know. But they didn't find it the night of the incident. They found it days afterwards is the problem. And then all of the medical experts have basically stated that the injuries that O'Keefe had is not consistent with being ran over by a taillight. If that was the case, he would have had massive bruising, major bruising, and like other injuries, not just his head. It would be like rib cage, it would be like lower extremities. It would be a lot of other things. The injuries that he had were basically minor abrasions that required some kind of rubbing of the skin, not consistent with blunt force trauma with the rear of a vehicle. And so you're hearing all of this and you're trying to deliberate all of this, and you see that picture. And I asked the question before this trial even started. I just don't understand why she's being charged with first degree with what is out there on the internet. At that time, I didn't know it was bullshit or not because we haven't had a trial. But this is literally closing arguments. They've had a whole 30 days of trial, and nothing has answered those questions in the affirmative for the prosecution. Yeah, there's a theory that maybe the snow melted. Maybe. But how do you reconcile that with the picture? 5:07 a.m. The incident would have happened hours earlier. Problematic. That's all I'm saying.
And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barros's description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so.
It's night and day. Okay, so before and after, it just begs the question, how did the taillight get like that then? You got the picture of the, there's just too much there. I just don't understand. Not only is she not guilty of the first degree murder charge, I'm not even sure that there's enough to bring her up for charges on second degree, but they've charged her with both. So she's been overcharged. Involuntary manslaughter? If this was a competent investigation in California, in a jurisdiction where I work, this would have been involuntary manslaughter all day. I don't understand why she was charged this way.
You'll recall that after John...
Before I forget, McCray, thank you so much for the 10. Says, okay, I have to respond to the drunk claims. There was no proof presented that the tall glasses that were given to her contained alcohol. I guess that's fair. So they were bar hopping. They're at a bar. You could have done like the Ocho Cinco thing where look, I can't drink because I'm training for whatever. So I'm just going to drink cranberry juice and everybody will think that I'm drinking. Maybe she was doing that. And maybe it was because of her medical condition. She had MS and Crohn's disease. So yeah, I guess that's fair. But the way that she was acting and carrying on, it just kind of fits the narrative better that perhaps she was just really inebriated. But full marks to McCray for bringing that to the table. Yeah, I guess I can't really prove what was in there other than, I want to say, wasn't there receipts of alcohol purchases and like they saw the bartender pouring the drinks? I don't know, but fair point to McCray.
His body was discovered. Blank, very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed.
Cray says that the only receipts that he saw was there's 2 shots of Tito's, which is a mid-level vodka. But then again, there was somebody else that had mentioned that she admitted on TV that she had 4 shots of vodka. Even 4 is a bunch. When are you tapping out on shots of vodka? Like after 1.5?
Yeah, depends on
Max.
the span of when I'm taking them. If I'm taking
God
them
forbid it's
back to back,
tequila.
yeah, you don't want that.
No.
But, have they addressed the witness,
Which one?
the snowplow guy?
Oh, not in the closing argument. No, you're talking about like the first couple of days of trial, I think. The guy that was that was trying to that was conducting a criminal investigation, a forensic investigation, and had a snowblower as he was like blowing away the snow. Is that the guy you're talking about?
I don't know if it's the same guy, if that's the one, but apparently there was some kind of witness that was on his route and did not see where clearly he should have seen a body at that place.
I don't think that either one of them brought that up in the closing arguments. But no, I don't think that was really that much of a point scoring issue for either side. But let's continue.
What with that whole thing about a dead body being on their lawn? That might get some attention. And they had to be wondering, will he set up the crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Lochran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Owls. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told.
All right. So this is for me personally, what he's about to go over right here is, and this is one of his last points or towards the tail end, just the scientific impossibility of the prosecution's case. And he's going to start talking about some of the testimony from his scientific expert who's going over the physics of it all. And this is what he has to say.
To you an opening statement was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. A magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle.
I don't know. That's not really much. Hey, hairs cling to things. Hairs, they survive lots of things. I don't think a blizzard is proof positive that you're going to get rid of all of the hair evidence, but I digress.
At 34 Fairview on January 29th. That hair was placed there.
Maybe.
The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces. And no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. while he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it, which means that was done intentionally. That was not a mistake. And when caught...
Yeah, look, there could be innocent reasons for inverting videos. Remember when I first started streaming, my video was just inverted for no reason, and I didn't know how to fix it. But what he said was important. If you inverted it, it hid the timestamp, which is why he thinks it was intentional, which I guess, you know, if you're purporting conspiracy theories, you don't have to believe in conspiracies to think that Karen Reed is innocent. You don't even have to think that she's innocent to think that she's not guilty. All I'm saying is that there's enough reasonable doubt floating around in this case where you're not going to get, in my opinion, a logical guilty finding by a jury. I just don't see it, but we'll see. I'm going to finish this. There's like another 10 minutes to go. I have it sped up at 1.25. I'm not going to get into Lally's closing arguments. Maybe I'll get into those tomorrow. We're still on verdict watch. If we don't have a verdict by tomorrow, it's like we're looking at like 70% odds on a hung jury, but we'll see. We're going to cover this tomorrow as well. We'll finish up with Jackson, and then we'll talk about some stuff with this case. Yeah, let's finish up.
On that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There's no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case: lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor, and he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mulaney, Michael Lang, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts State troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found about 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not stop and shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag. Under Mr. Lally's questioning, And you remember he hesitated just a second, opened that bag and pulled out one piece of clear plastic, then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all four of those back into the bag, sealed them up, and we're done for the day. The next day I asked about that evidence again. I asked.
Yeah, that's problematic to not know where evidence came from, and you're a witness in the case, and to have that full display on court and have to be questioned about it in trial. That's I mean, look, it might not be evidence of a cover-up, it might not be evidence of a conspiracy, but it is evidence of extreme professional negligence, incompetence, whatever you want to call it. It's a proof that you cannot rely on the evidence that points to Karen Reed's guilt because of the severe incompetence in the investigation. At best, that's what it is. At worst, it's a conspiracy, cover-up, whatever. Either way, how do you get to guilty from here?
To open up that bag with the red pieces, and he did the same thing. Pulled out two red pieces of plastic. I said, you recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a third piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37, and see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips, and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers in Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe, or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident.
That's kind of the point, isn't it? So the two, all right, when I started with this case, I wanted to know what was the state of the brake light, tail light. We know what happened with that. And then I wanted to know what the injuries were going to be consistent with. Is it consistent with getting ran over by a car? And what this guy is saying is that the prosecution's own witness, along with his witness, and all of the medical doctors and all the science experts that came in to testify basically said that his injuries are not consistent with being run over by a car. It's just as likely he could have been punched in the face and fell backwards and hit his head. And if the standard is reasonable doubt, all the defense's job is to present to you one other reasonable scenario that differs from the prosecution. And then by law, it is a constitutional truth. By law, you must find the guy not guilty. And so most damning in this case, I mean, I don't know if it's most damning, but one of the damning things in this case is that every medical professional does not agree with the prosecutor's only theory of the case. And it was mind-blowing to me that the guy was hell-bent on sticking with his initial theory that, oh no, Karen Reed ran him over with the car and then just took off. Didn't give any wiggle room for alternate theories. All he had to say was either Karen Reed hit him with the car or did something to cause his death and then sped off and making her guilty of one of these lesser includeds. And now at least the jury knows that you have an alternate theory that fits the facts, because his only theory was the car theory, and that doesn't fit the evidence. It doesn't fit the experts in the case. So what are we doing? I'm not saying that he's a bad attorney. I'm not attacking any of that. I'm just flabbergasted by the fact that he was so steadfast in his initial theory in spite of the evidence, and even in his closing arguments didn't do anything to give the jury anything to work with. Let's finish this up.
That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but two thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology. He told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rinchler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement, before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rinchler, both PhDs in engineering, both top of their field in accident reconstruction, both published peer review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rinchler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain.
I'm going to have to push back on that guy there. If he's never played football in Ohio, tackle football, I could full on confirm that grass and mud, dirt, turns into a, well, I don't know if it's ice, but it's pretty freaking hard. I'll say that.
His nose, they haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen,
No.
given what we know about the facts, the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat, talking about her bodily functions, her medical conditions, calling her.
Yeah, and when he was questioned on the stand for that, he was like, well, it was all regrettable. I shouldn't have done that. But yeah, he was doing that and didn't really deny it.
Vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object and went further by insulting her.
He says something about like, oh, she's hot, but she doesn't have an ass and she leaks poop, referring to her Crohn's disease, I guess. It was pretty vile what he said. Very disrespectful.
He went further than insulting her and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about, top to bottom, tip to tail. It's about the truth, not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you, not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies, the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth, and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Read is innocent. Do justice and find her not guilty. Thank you.
All right, man. So, look, I challenge anybody that's out there listening right now or that's in the comments to convince me that guilt is a thing here. Convince me that the prosecution has proven its case, knowing the obvious holes in the evidence, knowing everything that he laid out. It's not like he's just bullshitting right now, because that's pretty much how the evidence went down. None of the medical experts lent themselves to a professional opinion concluding that the injuries were caused by Karen Read's car. None of them, not even close. The investigation was wholeheartedly deficient from the very beginning. Anybody, make the case for me. What do you got, Jules? She says it's not. He's literally speaking facts. No, that's the thing. There was nothing here. It was so bad, in fact, that I was wondering from the very beginning why she was charged with first-degree murder. And now that the facts have come out, I'm wondering why she's even charged with second-degree murder, knowing how the investigation's played out. I would have been okay if they charged her initially with second-degree murder and then amended it to involuntary manslaughter based on the investigations. Problem was that didn't happen because of who was close to the investigation. And so what do you have? You have a situation where it really looks like there is some corrupt law enforcement officials that were in charge of this case and that manipulated evidence and that tried to pin this lady, Karen Read, for whatever it is, your opinion of her, to sentence her to life in prison for what? Because you're trying to protect the old boys club, or what? Is that what we're doing over there in the Commonwealth over there in Boston, Mass? Look, I don't know a whole lot about Boston. I listen to this guy, Bill Simmons. He's from Boston. He's a podcaster. The Celtics, they just won the NBA Finals. Good for them. I'm a Lakers fan. I've never been to Boston, but I have never been of the opinion that they were capable of this level of deficiency and investigation into a serious crime such as this. Made all the more egregious, given that the main culprits in everything was closely tied to law enforcement. I don't know. Hey, make the case that Karen Read is guilty. Do it. Ready, set, go.
Can't.
All right. Well, there it is. There it is. There it is. I don't know. Does anybody have a better argument than that one? I don't know. Folks, we've been going for 2 hours. I have been ignoring this case for a long time because of Laura Owens' nonsense. I know that she posted another article. I'm not interested in it. I'm not covering it. If there's anything else to cover on her, I will. But for this Karen Read, I'm expecting that a verdict is going to come down tomorrow morning. If it doesn't, then I will cover Lally's cross-examination. It was this meandering thing. He kept on making these emotional arguments, trying to convince the jury that she had a motive to murder. I mean, she had a motive to be pissed off at her boyfriend, but to stretch it into she definitely ran him over in his car. It would have been a smarter argument to say that she was pissed off and, not knowing what she did, backed up really fast and accidentally hit him, not knowing that she hit him, and then sped off. But he never really said that. He just was going with his initial theory to begin with. I don't know. What do you think about it? The uterus, the sandwich maker.
As far as the prosecution's case?
Yeah.
Well, I haven't heard anything about it.
Well, based on what you just heard Mr. Jackson say, under what context would you say, well, how would you assume that this case is going to go? Just assume like you were on the jury. Like, what questions would you want answered?
Well, first I would have to lay out all of the evidence that they've presented and then try to pick apart what evidence has been either manufactured, manipulated, or just has to be thrown out because of incompetence. Figure out what's left.
Well, you can't throw it out for incompetence, but what you can do is take it to trial and get your ass kicked because of the incompetence, which is kind of what I feel like what's happening. Now, look, there was a lady that came in and I read her comment in the first 5 minutes. She's like, I was going to listen to your show because you sounded like a smart guy, but you know what? You don't have a clue, because I'm assuming she was of the side that she wanted Karen Reed to be guilty. And I kicked her ass right out. Well, I don't know if I kicked her out. She said she wanted to leave. I would have kicked her out. But hey, I don't get the crowd of people that are hell-bent on finding Karen Reed responsible with the evidence the way that it is. And so if there's people out there like that, just make the case. But you got to do it with the evidence that's been presented at trial. We've had 30 days of evidence, which is like 4 times more than most cases get, like of this profile anyway.
Right. I'm sure that there are people, but I think it's going to be very difficult for them to have justification for their reasoning other than they want to believe in the justice system. They want to believe in, law enforcement doing what they're supposed to be doing. And
do you believe in the law enforcement system?
I mean, I believe that there are a majority of people trying to do their job and do it the best of their abilities.
Oh, that's such a nice answer. You're such a sweetheart for saying that.
But I mean, of course, there's going to be some bad apples, and there's going to be some bad apples because of incompetence, and there's going to be even fewer bad apples because of whatever reasonings that they have.
I guarantee this is what's happening in the deliberation room. There's probably 10-2 in favor of complete acquittal. And the 2 that are holding on to second-degree murder because they're convinced by those really mean voice messages that were played in open court, where she was really pissed off at him, and maybe she just did something in the moment and forgot about it because she was so drunk.
But they're writing this whole thing on premeditation, are they not?
No, because second degree does not require premeditation. Second degree only requires that you were pissed off in the moment, and in the heat of the moment.
Charging her with second degree.
She's been charged with first degree, second degree, involuntary manslaughter, and fleeing the scene of the incident. Like 4 different things. And so they have to decide whether or not she's guilty. I don't think there's a shot in hell in first degree. There's no way they could prove premeditation. They're all out having a good time, which is another reason not to bring charges for first degree murder. But they did. So second degree murder, fine. In the heat of the moment, she got pissed off because he was, I don't know, she was mad. Time with the kids and all. She was screeching at him in the voicemail. She was pissed off as she called him 50. Yeah, she called him 53 times, looking for him, and she was on that tequila mad, okay. She's on that vodka mad, not tequila. And they're holding on to maybe she got pissed off enough to do something really dumb and she don't remember, but the evidence doesn't fit that either. What did she do? She didn't beat him up. She either hit him with the car, she didn't, and none of the experts have corroborated the hit him with the car story. So where do we go from there? Do you want to go involuntary manslaughter? You have to show some involvement with the car for me to find him guilty of that.
What is the prosecution saying exactly how she ran him over? He got out of the car.
She intentionally, well, for first degree murder, she's saying that she formed the mens rea in the moment when she was so pissed off. She saw him there and she revved up the car and floored it, and at 25 miles per hour, as she was backing up, hit him with the car, took off, forgot about it.
I need to see some kind of
I mean, that's the theory. Am I getting that wrong, chat? Because that's what I understand the theory to be. That's one theory. The other theory is in the moment she decided to do that, so second degree murder, they allow for second degree. But the lesser included of that would be involuntary, which is she didn't know that she did it. She didn't know that she hit him, and then she just sped off because she was so drunk. But you have to show me some connection between the incident and the car, to which there is none, because the broken taillight even was shown on photographic and video evidence in the trial to have occurred at 5:07 in the morning. They had a before and after at 5:07, and when they had the car after the incident, looked completely different,
So
which
they showed that
suggests
had it in custody, and then there's
the incident would have occurred like around 1 or 2 in the morning or something like that. We have video evidence of it, what it looked like at 5:07, and it was just cracked. It wasn't shattered, and they literally pulled remnants of the tail light out of his clothes. So how is that possible if it wasn't planted? It's more probable to me that I don't believe the conspiracy theory, but it's more probable to me with the evidence that's been presented that the conspiracy theory is a thing, more so than Karen Reed hit him with the car, causing his death. I would entertain the sideswipe theory, which is she got pissed off in the moment and like backed off really fast, and he threw his whiskey glass at him and hit the taillight and slipped and hit his head on a rock because he was so drunk. I would buy that before. He's dead for a reason. Either you believe something happened, or somebody in the house caused his death some kind of a way.
Explain the lacerations on his arm.
Dogs. That's the other thing. The lacerations on his arm are consistent with a canine, with a dog, such as a German Shepherd, 80 to 90 pounds, attacking him.
Right.
What's more important is you can't just say, oh, maybe it was coyotes. No, because the doctor said that those injuries occurred while he was still alive for medical reasons. And they explained it. And so that's why I'm saying I feel like it's probably 10-2 or 11-1 in favor of full-on acquittal, and they're hung up on the involuntary manslaughter thing. That's what I think is happening. And if that's the case, you're going to have a verdict by early tomorrow morning. If this goes on beyond tomorrow morning, then I think that you're more likely looking at a hung jury because some dipshit in there is just digging in their heels.
Yeah.
And they don't want to deal with it anymore, and they're not going to budge, and we're sick and tired of this. And it's a 12 angry men situation that's failed to launch, and they're saying, F it, we're going home. Which I think the judge would probably say, well, why don't you just deliberate one more day and then we'll see. But I feel like that's where we're going. Jules says the dog that they conveniently got rid of right after this happened. Yeah. And they got rid of the dog. And then I think, didn't they sell the house? They got rid of the dog and sold the house like shortly thereafter. A house that had been in their family for generations. Oh, what's up, Robin? Robin says, where do they go drink? Was it Betty's? Because that's a hot spot. I don't know anything about that. I just know that they were bar hopping in the area and having a night in their 40s.
I was just about to say, I'm like, aren't they like pushing 45, 50?
Man, I'm older than you, and you have less of an appetite to do that than I do.
I am an old soul who likes to be at home a lot.
You're just an old lady at heart. It's just how it is. I don't get the bar hopping fascination. For what, man? Pick a place and stick with it. And
in the snow, no less. You're drinking
in a blizzard.
To go out.
It was like 37 mile an hour winds, and snowing is freaking cold. It's probably like in the 20s. It's the hell with that.
It doesn't sound pleasant.
We will look at the weather. We'd be like, you know what, the hell with that. We're cracking open a bottle of wine. We're gonna watch Netflix or something. Let's watch a documentary about birds. That would be your vote.
There's nothing wrong with that.
Other than it's boring as fuck.
David Attenborough has like the best voice.
Well, he's like 98 years old, so you're going to have to find another voice pretty soon.
Well,
but you never know.
Is good too.
He might outlive me for all I know. Jules said they're mad dumb. They covered the tracks and got out of Dodge so they couldn't investigate the alternative theory. Yeah. No, not the birds. Yeah, the birds. She's a fan of birds. Those nature shows. I can't stand it, man. She puts that on for the kids. That's like a hospital waiting room entertainment. Why would you watch that on purpose? Oh, so hey, Dominic, you want to talk about the Patreon? You want to come on? Dominic, the gym bro. Hey, do you know what? Dominic is like he's 25. He's like the youngest Uncle Rico you ever heard of. how much you want to bet I could throw a football over those mountains? I don't want to show a picture of my legs. My legs are so big.
Facts.
But I had to send you a picture at 11:30.
I had to show him off, man. I had a good pump that day, but
I was, you know
no,
what, man? I was gonna send you a gym selfie from this afternoon, but I was like, why would I? What am I doing? No, I'm not doing it. I'm gonna send a gym selfie to a guy.
You're just reciprocating the love.
yeah, exactly. But no, as far as the Patreon goes, the Patreon is live right now. If you guys want to check it out, the link should be. I think it's in Discord. I'm not sure if I have it in Discord or not, but it should either be in Discord or the new TTL clip should have it in the description. But this Friday, when I go in to record with Omar, we're gonna do a segment just for Patreon, which is gonna be the whiskey reviews. So look forward to that. That's gonna be posted on Patreon, I believe, depending on how fast I get the editing done, either Friday night or Saturday afternoon, around there. And then I believe Omar also wants to do a Patreon only stream on Saturday.
Yeah, we're
So look forward to
gonna
that.
do either a poker night or we're gonna do like the People's Court or something. What did we say
Yeah.
we're gonna do? Is the Tilted Court, and we're gonna have paid Patreon members present their case against some random unsuspecting folks. I'm going to be the judge. When we do our poker nights, we're gonna have it literally in my garage. We're gonna set up the poker table. Dominic's gonna be invited. We're gonna have alcohol. The Tilted Uterus is gonna be in there making sandwiches and such. And no, she ain't gonna be making shit.
Snacks.
That's my production. There's gonna be hors d'oeuvres. We're gonna have a good time with it. Also, we just set up. I know that there's not any really any content on it right now, but we're gonna start putting stuff. I set up a NSFW chat for the Patreon. It's gonna be stuff like what we were just talking about, like gym pictures and stuff. It's just stuff you wouldn't say to your mom. It's nothing like OnlyFans or anything. It's just stuff to talk about with grown folks conversation. You guys go in there and talk about whatever you want. How about that? Uncensored, strictly for the paid members. We're gonna be doing, what else do we say? You said you wanted to have like a office watch party or something.
Oh yeah, some people were mentioning, the office watch party, so we're gonna have to agree on which office though, because I know we have some British people in here that prefer the British office, but
British office, man. The British office is where it all started. It originated. And you can't make the argument that Office America wins season 1 because they literally like took the same script and it was like British office karaoke. Literally until like I think after the 6th episode. I don't remember. But yeah, no, they look, if you're not that why are we talking about the office right now? But the British office, you can't touch it.
we could have a whole debate. Maybe that'll be for the Patreon. We'll have a debate on stream.
Yeah. But hey, folks, go to the Patreon, be a part of it because it's going to be something. We have
also
a Friday show with Ileana coming up. It's probably going to be about more Karen Reed stuff because I suspect around that time we should have a verdict by then. And if not, then we'll find something else to talk about. It's either going to be that or I do want to talk about the Michael Miller case because that was the other one we were talking about before the Laura Owens nonsense, which we're not covering anymore unless there's a real good reason to cover it. So you were going to say something, Dominic?
Oh no, I was just gonna say also this Monday on the 1st, July 1st, we will be dropping merch for the TTL. So be on the lookout for that as well.
Oh, yeah, the Tilted Lawyer whiskey glasses, Tilted Lawyer wine glasses. We're gonna do the Tilted Lawyer gym shorts. I don't know, whatever, something. It'll be something. All right, man. I will see you guys. That's all I got for you today. I will see you guys likely. Probably tomorrow. We're gonna do another one tomorrow. About the Karen Reed. We'll dissect Lally's closing arguments, and of course, if they have a verdict, we're gonna have to go right in. I might have to bring Ileana for that one, and we might have other guests as well. But thank you guys so much for sticking with the show for the entire podcast. If you've been doing that, and we will see you guys. Well, I guess we'll see you tomorrow. Bye bye.